In recent months, the Supreme Court has granted a string of emergency orders in favor of the current administration, producing what often amount to temporary legal victories, while major underlying disputes continue to await full adjudication. The so-called emergency docket, sometimes referred to as the shadow docket, enables expedited intervention, pausing or altering lower court rulings before the full merits of cases are heard. Supporters argue that many decisions reflect a deliberate effort by the justices to restrict expansive rulings by trial courts, signalling a judicial philosophy that prefers restraint and deference to executive and legislative authority. One legal scholar observed that the court's pattern suggests it is asserting that lower courts have overreached, stepping in only when parties claim they would suffer irreparable harm. The administration has invoked this pathway in a wide array of contentious areas: mass firings of career civil servants, high-profile dismissals of officials appointed by the prior administration, nationwide injunctions on federal policies, aggressive immigration practices, foreign aid withholding, and removal of transgender service members from military roles. On many of these fronts, the emergency orders have succeeded in stalling or overturning lower court decisions, at least for now. For example, the court has allowed the government to withhold billions of dollars in foreign aid, affirm emergency deportation tactics, and limit the reach of nationwide injunctions. In one notable case, it upheld the executive's decision to remove a commissioner at a federal agency, while reserving judgment on a long-standing precedent concerning the independence of such regulatory bodies. Still, not all requests have met with approval. In one instance, the court declined a request to immediately permit the removal of a Federal Reserve governor, opting instead to hear the case in full at a later date, an unusual deviation from prior emergency docket behavior, in part because of the sensitive and traditionally insulated role the Reserve occupies. Legal analysts caution that these emergency orders are provisional. As cases advance to full briefing, argument, and final decisions, the court may reverse or narrow its earlier stances. One former government attorney warned that the record of emergency wins should not be taken as a guarantee of ultimate success. Indeed, the court's emergency orders tend to supply very little reasoning, often leaving unclear how far the court intends its rulings to reach, and that opacity can complicate litigation strategies going forward. The upcoming term of the court is expected to be pivotal. It offers the justices a chance to fully weigh the constitutional and statutory arguments underlying the emergency rulings. In some disputes, the court may reaffirm the interim relief. In others, it may claw back authority from the executive branch. Observers expect that the high stakes involved, covering separation of powers, executive authority, federal regulation, and individual rights, will turn these cases into defining tests of the court's role in the modern legal and political environment. In sum, the current administration has amassed numerous wins via the emergency docket, halting unfavorable lower court decisions in key policy arenas. But those gains are fragile. With the new term, the full court will confront foundational constitutional questions and decide whether to entrench or unwind many of the emergency rulings granted to date.